Educating students in the public school system is shaped by a combination of federal, state, and local statutes, regulations, negotiated agreements, and established, if not always best, practices. The rules and regulations that guide how we approach educating students who receive services under one of the 13 disability categories ranging from mild learning disabilities to significant cognitive or physical impairments grew out of the civil rights movement, including the equal protection standard established by the Brown v. Board of Education case in 1954. It is important to understand the history and traditions associated with public schools and special education, as children with disabilities have not always attended and have been able to attend their home school where children without disabilities attend. In addition to assurances of civil rights of students with disabilities, other legislation exists that addresses their educational rights, and we will address these during this lecture. Special education is a dynamic field. Court cases and laws continue to evolve and change by name, by purpose, and these changes directly impact what we do in our classrooms and how we support individuals with disabilities. Let's quickly review what constitutes special education so that we all have the same understanding before moving on. Special education is the vehicle through which children who have disabilities are guaranteed to receive within the public education system an education specifically designed to help them reach their learning potential. It's a customized instructional program designed to meet the unique needs of an individual learner. Sometimes special equipment, technologies, services, and teaching strategies are used to deliver and meet the needs of an individual. Special education is just one component of a complex delivery system designed to assist a student in reaching his or her fullest potential. Remember, though, students with disabilities have not always received the same rights to education as other children without disabilities. Let's take a look at some of the legislation. The Elementary and Secondary Education Act, ESEA, was passed in 1965 as a part of the War on Poverty. ESEA emphasizes equal access to education and establishes high standards and accountability. The law authorizes federally funded education programs that are administered by the states. The ESEA, by and large, governs federal policy that addresses K-12 education and has been known as the General Education Law. Since 1965, the federal government's role in education has grown significantly, and there have been many reauthorizations to the ESEA, some of which we will discuss later. Why are we talking about general education legislation? Well, this is the underlying legislation for NCLB and ESSA, which we will address later. The landmark law for special education was passed in 1975, and it was called Public Law 94-142, and at that time, it was the Education for All Handicapped Children Act, better known today as the Individuals with Disabilities Education Act, or IDEA. Children were first allowed civil rights to education in 1975 with the passage of Public Law 94-142. This law has been revised many times, and we will cover some of the more important revisions. This legislation contained core principles to ensure the educational rights of students with disabilities, which we will address in the second part of this lecture. I'm going to jump ahead for just a moment because I want you to know right now that IDEA establishes all of the parameters and rules for special education. The law specifies 13 disability categories in which children are eligible to receive a special education. Children who have characteristics that are aligned with the definitions for these disability categories are eligible for resources, services, and supports to help them learn. A school district receives funds from the state of Illinois and the federal government to educate any child who receives services within any of the 13 disability categories. IDEA applies to children 0 to 21 years, actually through their 21st year. Over the years, there have been many amendments to the Public Law 94-142, or the Education for All Handicapped Children Act. A few of the important changes include, in 1986, amendments extended the law to young children. Prior to 1986, the law only applied to children ages 6 through 21. The 1986 amendments set up early childhood education programs to cover children between 3 to 5 years old, and the states were mandated to provide these. Additionally, provisions recommended that states also set up the infant toddler programs to cover children ages 0 through 2. But this is actually voluntary on the part of each state. But every state has a 0 to 2 program. The changes to the law in 1990 were important because autism was added as its own disability category, as well as defined traumatic brain injury for school services. It was also decided then that ADHD was not going to be a disability category, as it's still not today. We also decided that transition services were critical and the law required schools started planning for older students to transition. It was noticed that students with disabilities weren't being as successful as their non-disabled peers, so schools needed to include a transition plan for students. Federal legislation requires transition planning must start by the age of 16. However, in Illinois, the age when we need to actually begin a transition plan is 14 and a half. The 1997 amendments were important because they took back the zero reject principle just a little bit. If a child brings drugs to school or a weapon to school, the child can be expelled even if the child has a disability in an IEP. It also required that students with disabilities are included in state assessments. There are two other laws affecting special education that are important to learn about. The Americans with Disabilities Act of 1990, or ADA, and Section 504 of the Rehabilitation Act are civil rights laws, not special education law. They have resulted in increasing numbers of accommodation plans in our schools. Without going into details about these two laws, Section 504 of the Rehabilitation Act is always the one that is applied to schools because schools receive federal money. So from this point, we will refer to Section 504 and 504 plans, but realize the same legal principles apply because of the law ADA. It's important to know that students may have a disability, but they will not necessarily meet the eligibility criteria for special education services. As you recall, there are 13 disability categories within IDEA, and each category has a specific disability criteria and definitions. In Section 504 of the Rehabilitation Act, disability is defined in a broader way. Because Section 504 has a much broader definition of a disability, more children are covered under Section 504 than are covered under IDEA. Children who do not qualify under IDEA, which really means that their disability does not impact their educational performance, can qualify for protection or accommodations under Section 504 of the Rehabilitation Act. If a child meets the definition of a disability through the Rehabilitation Act, Section 504, the school is obligated to provide that child with reasonable accommodations for their disability and equal access to educational opportunity. Section 504 is not as specific of a law as the IDEA. Section 504 plans get their name from Section 504 of the Rehabilitation Act, and they focus on how a disability will be accommodated in the classroom. It is not an individualized education plan, an IEP. There are not goals or objectives, and it is not nearly as involved as an IEP. It is a plan that assures accommodations to help the student be successful. A 504 plan that requires a school to make accommodations is a far less intense obligation on the part of the school than an IEP. Nobody would have both an IEP and a Section 504 plan because there is a section within the IEP that also includes the accommodations a student needs and would include everything that would be in a 504 plan. For instance, if a student needed extra time taking a test in order to show what they know because of a disability condition, then that would be in a Section 504 plan, that the student be allowed extra or extended time when taking a test. Another example of a student served through Section 504 might be one who has type 1 diabetes. Through Section 504, the school district would ensure that the school professionals working with the student understands his needs and that the student has immediate access to snacks and water and that the student is allowed to use the bathroom whenever requested. The student does not need the educational services of an IEP. To clarify, let me ask you a question to make sure you have this straight. Can a child not be eligible for an IEP, but be eligible for a Section 504 plan? The answer is yes. The difference between an IEP and a 504 can be very confusing to teachers, administrators, and especially parents.
Perhaps you've heard of a 504 plan. Well, we'd like to explain the difference between a 504 plan and what it is to be in special education and have an IEP, or an individualized education program. So what is a 504 plan, Jen?
Okay, so 504, and the term gets thrown around, 504, 504. What it is Section 504 of the Rehabilitation Act of 1973. In English, it's an Accommodations Act. It is a civil rights act that says that any entity that receives federal funding, and that includes schools, but 504 doesn't just apply to schools,
Right.
cannot discriminate against people on the basis of disability, nor can they deny the benefits of the institution or the agency because of disability. And that's a very mouthy way of saying that if your child requires accommodations because of their disability, they're entitled to a 504 plan. And the easiest way for me to describe the kinds of cases which would easily fall into the category of 504 versus an IEP under the IDEA, the Individuals with Disabilities Education Act, which is a different federal law, is that 504 is an Accommodations Act and IDEA is a Special Education Services Act, okay? Now, the IDEA also allows for accommodations. A good way to think about it is that an IEP under the IDEA would very likely meet the requirements of a 504 plan because a 504 plan really is only accommodations. The reverse is not true. Why does all of this matter, okay? Here's why it matters. Let's just say a child has a peanut allergy, and because of a peanut allergy, they need accommodations in school. Perhaps there are certain materials that can't be used in the cafeteria or in the art room because the child is allergic and there's peanuts in that particular equipment or in those particular foods, and so we need to give that child accommodations. There's nothing different about how that child learns. They don't need any specialized instruction in order to access their education, leaving out some other kind of a disability. So that child would probably get a 504 plan. A child who requires specialized instruction requires an individualized education program under the IDEA. Those are easy examples. The harder examples are a student who has, say, an attention deficit disorder. Well, perhaps they need a 504 plan, but if it rises to the level where the child requires individualized instruction and related services, then that child might have an individualized education program. I get brought in a lot where parents have a 504 plan and they don't think it's sufficient. They think the child needs more than just preferential seating or on-time testing. They think the child needs services, someone instructing the child, someone who's trained to instruct the child to remediate the disability. And that's where the dispute comes in. It's easy when it's a peanut allergy, but it's much harder where it's a disability that sort of crosses the edge from accommodation to services.
And you know how I like to explain it? You've explained
Easier than mine?
A little bit. You've explained it very well, but if I had to just succinct it down a little bit, is I like to say that you can have a disability and have a 504 plan and not, like you said, rise to the level of having an individualized education plan. A 504 plan says, the school says, we recognize the fact that your child has a disability, and we will accommodate him or her, and we will modify things for him and her. But we don't believe that their disability rises to the level that it has an adverse impact on their education. Right? And so that's the confusing thing about it. You can still have a disability and get the 504 plan. Or you can have a disability and rise to the level of having an individualized education program. So in a nutshell, that's 504.
That's 504. Here's the other piece that I think is important. I'm sorry, but I have to say it. Many school districts prefer to give kids 504 plans versus IEPs because it's easier. A 504 plan could be one page and it could say, Johnny will have preferential seating. It's not so easy to comply with the IDEA. It requires a lot more work. Parents have far greater protections under the IDEA, in my opinion, than they do under Section 504. Section 504 is an essential statute, and it applies to a lot of situations that are very important to keep in mind. But very often when a parent calls me and says, my child has a 504 plan, and I've been feeling for a very long time that they need services, I sort of roll my eyes because it's not not that uncommon that a kid gets a 504 plan when really they're supposed to have an IEP.
I think the most important thing is for parents to understand that there is a difference between an IEP, an individualized education program, and a 504 plan. And just knowing that is half the battle.
It's at least half the battle.
In 2002, Congress amended the Elementary and Secondary Education Act from 1965 and reauthorized it as the No Child Left Behind Act, NCLB. Remember, ESEA is the nation's general education law, and from 2002 to 2015, it was known as the No Child Left Behind Act. In December 2015, President Obama signed the latest reauthorization of ESEA to replace NCLB with the Every Student Succeeds Act, or ESSA. Given the importance of these acts in the lives of children with and without disabilities, it is important that you be familiar and understand some of the important provisions of NCLB and ESSA. The signing of ESSA is a very big deal because if you hadn't noticed, many people disliked NCLB. No Child Left Behind put more power in the hands of the federal government in terms of education, which has always been a state government concern. It also brought about high-stakes testing and teacher evaluations that were based on the results of those tests. Rather than spending time going over what is now old legislature, I will have you view this video that simplifies some of the key differences between NCLB and ESSA. In the notes section, I also provided you with a document by the ASCD, formerly known as the Association for Supervision and Curriculum Development, that compares the two laws in more detail.
You've probably heard of No Child Left Behind, the federal education law that's been on the books since 2002. The era of No Child Left Behind, a law a lot of people really hated, is over, and the Every Student Succeeds Act has replaced it. There are a lot of questions now about how ESSA, as it's called, will work.
So how is ESSA different from the No Child Left Behind Act?
So No Child Left Behind put a lot of power in the hands of the federal government. They were kind of the big dog on the block. And ESSA seeks to really roll that back, giving states and school districts the chance to call the shots on things like testing, teacher quality, and fixing failing schools.
No Child Left Behind is working.
This bill makes long overdue fixes to the last education law.
Do kids still have to take tests every year?
So let me think about that. Yes, kids still have to take yearly tests in reading and math in grades 3 through 8, plus one time in high school. And schools still have to report test scores.
How does ESSA rate schools differently?
Good question. So even though kids still have to take those yearly tests, ESSA wants states to look at a broader range of factors. States have to pick at least one other indicator that gets at whether kids have the opportunity to learn. That could be access to advanced coursework, maybe school climate. Plus, ESSA gives states a lot more flexibility when it comes to the tests themselves. Districts could decide to have high school kids use the SAT or the ACT instead of the state exam. Plus, under ESSA, a handful of states can experiment with new forms of testing, allowing students to work together on performance tasks instead of those fill-in-the-bubble tests that we're all used to.
What kinds of requirements does ESSA have for teachers?
So under No Child Left Behind, teachers had to be highly qualified. That meant that they had to have a bachelor's degree in the subject they were teaching plus state certification. A few years ago, the Education Department gave states some wiggle room on that requirement, as long as they promised to evaluate teachers in part based on student test scores. As it ended up, though, a lot of teachers found that frustrating. It was really hard to get those evaluations right. Under the new law now, states are in the driver's seat when it comes to teachers. They can decide if they want to stick with highly qualified or those evaluations based on test scores, but they don't have to do either.
And what does ESSA say about the Common Core?
So ESSA says states must set standards that get students ready for college without the need to take remedial courses. But the federal government can't tell states what their standards should be or encourage them to adopt a certain set of standards, including the Common Core.
What does ESSA say about low-performing schools?
States will still have to identify and fix the bottom 5% of schools and those with really high dropout rates.
Hold on a moment. Has ESSA already hit schools?
Not quite yet. It won't be fully in place until the 2017-18 school year. Many of the decisions about how to judge student performance, improve schools, and hold teachers accountable are going to have to be made by states and districts. If they choose to stick with what they're doing now, things aren't going to change very much. If they go off in a very different direction, though, we could see big changes.
Congress, prior to the 2004 reauthorization, was afraid educators had low expectations concerning students with disabilities, and that educators were not focusing on what worked, not using research-based techniques to teach students with disabilities. The reauthorization of IEDEA focused on increasing the academic achievement of students in special education, writing measurable goals and actually measuring them, and on progress monitoring. IDEA 2004 focused on high expectations, access to the general education curriculum and environment, strengthening parental involvement, coordination with other educational reform acts, and providing students with what's appropriate. You'll notice that over time there have been many changes to special education laws and regulations. Toward the beginning of the 20th century, many efforts needed to focus on providing access to education for all learners. Around the turn of the century, we really began focusing on the quality of instruction students receive. The history of special education documents periods of deplorable practices that really do help explain why today's laws must exist to protect students with disabilities. Before